so much.
Okay, then you can stand up. Stand up and speak.
Yeah.
Yeah.
Yes. I stand before the Supreme Court of India to tell the world with a greater sense of responsibility, pain and anguish that Supreme Court as an institution and the High Courts have failed to grant to the make available to the MSMEs what the Parliament has ordained. The Parliament enacted the MSME Act of 2006, and after a great deal of consultation between the Ministries of Finance, MSME, Bankers Association, Reserve Bank, and the other stakeholders, including the MSME Association, the government issued a notification dated 29/5/2015 for a framework for resolution of the sickness of small-scale sector. The said notification received the assent of both houses of the Parliament, and it thus became a law. When it became a law, it is as good as an act of Parliament, a statutory instrument as good as an act of Parliament. The notification mandates the banks and financial institutions to identify incipient stress, then come to their rescue by classifying the account as a SMS 0, that is where before there is a default. When the early signs of incipient stress is noticed by the bank, then the bankers are required to constitute a committee, and the committee is required to make an effort for resolution of stress. And the committee, the Parliament in its wisdom, the government in its wisdom felt that should be primarily a committee which is under the control of or consisting of the officials of the bank. The committee has 4 members. Out of the 4, 2 are the officers of the bank, a subject expert who is from outside, and the representative of the state government. And the committee, if the committee finds that resolution of stress is not possible, the committee is permitted to initiate recovery proceedings. And the mandate of recovery is entirely left to the committee. And the scheme which came into effect on 29/5/2015 has for almost 10 years has not been given effect to. The primary reason for that failure is on the part of the Reserve Bank of India, the regulator, which did nothing to enforce the notification. But equal fault is on the part of the courts in this country, including the Supreme Court before whom I stand, where whenever an MSME came for enforcement of the rights, the courts were giving reasons absolutely untenable, I would say weird even, to deny them benefit. The first round when these litigations at the hands of MSMEs, the court said the MSME Act, the SurfaceE Act will prevail over the MSME Act. The SurfaceE Act was enacted in 2002. The MSME Act was enacted in 2006. A later law will always prevail over the pre-existing law. And it gave a judgment known as the Kotak Mahindra Bank versus Kainar Industries. In that case, the Kotak Mahindra, the dispute was not between a borrower and a banker. The dispute was between 2 creditors, an MSME as an unsecured creditor and the bank and financial institutions secured creditor. Under the MSME Act in terms of section 24, the act has an overriding effect, and the MSME unsecured creditor had a overriding right over the secured creditor. And the Supreme Court held in favor of the secured banks that between MSME as a creditor and MSME as an unsecured creditor and the bank and financial institutions as secured creditor, the banker will have primacy. But that is a wrong decision. But it has no connection whatsoever with the recovery proceedings. The recovery proceedings, the dispute is between the borrower and a lender. The Kotak Mahindra case, the dispute was between 2 creditors. The borrower, repeating MSME as a creditor, unsecured creditor, bankers as a secured creditor. This was the first round of reasoning given, and so absurd the reasoning. Then we kept on fighting for the cause, and the bench of the Bombay High Court held, after keeping the judgment reserved for almost 6 months, that the notification is not mandatory; it is only directory. Then the MSME Act is a preventive legislation to prevent MSMEs from falling sick. It's a remedial legislation, that is where the MSMEs have fallen sick, to bring back them to this life. It's a benevolent legislation, it's a welfare legislation, but still the Bombay High Court took such a view, against which we came in appeal, and many times there are different parties in this petition, and every time an SLP is filed, SLP was dismissed. Eventually, since we persisted on the philosophy that drops of water, it hollows a stone, not by his force, but by persistence. So keep on, placing faith on the court in spite of all the bitter experience. And eventually, on the 1st of August 2004, the bench of Justice Bera Trivedi, I am grateful to that ladyship, that the Bera Trivedi's bench held that this notification is mandatory, binding, and banks and financial institutions are duty bound to give effect to it. But whatever has been said in favor of the MSMEs has been watered down by certain observations. Says that if the MSME had not brought to the notice of the bank that is an MSME supported by verifiable documents, then the claim cannot be later. Then the claim as an MSME cannot later be raised. There's something called a doctrine of waiver, acquiescence. So MSME notification is a preventive legislation, is a welfare legislation. The duty is cast on the banks and financial institutions to act proactive, go in search of the MSME, and the RBI notification dated 17/3/2016 indicates the signs of illustrative signs of incipientness. For instance, where a check is bounced, then that is a sign of distress. So then that reasoning is absolutely absurd. But using that reasoning, thereafter high courts after high courts kept on dismissing the pleas of the MSME. So in short, the MSME Act and the notification, which is the will of the people, the mandate of the Parliament, the order of the Parliament, has been completely ignored, and the benefit of the notification has not been given to a single MSME. And no courts would ask, did you ever constitute a committee? Did you ever give a benefit to one single MSME? No, such questions are never asked. The courts are, I'm afraid to say, always is against the less advantaged sections of the society. The courts are always against the poor. The courts are always against the small entities, and because of this attitude of the courts, that has led to the homes of the units of thousands and thousands of MSMEs they allowed to be taken possession of soul, and they be rendered homeless and jobless, and forgetting the fact that MSMEs constitute 60% of the employment, 35% of the GDP, and about 40% of the export. It is such a vibrant sector. The notification came to be issued in recognition of this fact, and the very MSME Act has been enacted, noting that this is the vibrant sector which is the backbone of India's economy, and today world over the focus is on MSMEs. So therefore the courts are, I am afraid to say, are for the rich, the mighty. The courts have no time for the ordinary litigant. Ordinary litigants cases are dismissed in 93 seconds, while on the contrary, the courts liberally entertain the pleas of the rich, powerful, and the Supreme Court of India, I am afraid to say, has done a great deal of injustice to the common people. Then often I am asked, Nirmalaji, why don't you enter the street? Why don't you conduct a dharna? Why don't you protest against the court? But as a lawyer, I believe the courts are, and the lawyers, the job is not to take the litigant to the street. That is not our job. Our job is to place trust in the institution, because there is nothing wrong with the institution. The problem is with the people who are the humans, infallible humans. I am not against any individual, judges or any individual. The institution are manned by human beings, fallible human beings. So therefore there is always a prejudice against the poor. The elitism is there, because who are our judges? Who become the Chief Justice of India? All the kith and kins of judges, senior lawyers, and the powerful the chief ministers, governors, etc., and those who are politically connected. So who become the judges of the Supreme Court? The judges, sons, kith and kin of the judges, former attorney generals, senior lawyers, powerful ministers, and the common man's children have no place here. Who become the Chief Justice of the High Court? The same thing. So our institution is, our Supreme Court is entirely, elite, the elitism. And the courts have created the division among lawyers. They have made two classes of lawyers. Of course, they justify, they say that there's a Section 16 of the Advocates Act says there shall be two classes of lawyers. That is absolutely absurd, absolutely unconstitutional, absolutely unjust, absolutely unequal. And when we come to the court and say that this section is unconstitutional, there shall be only one class of lawyers, that pleas are dismissed. So therefore, the common people, many of my friends, lawyers, litigants, MSMEs, they say, sir, let us enter the street. They are right. To enter the street is a democratic means. But we have seen the peril of entering the street. It is not going to be a solution. We have seen what has happened in Bangladesh, what has happened in Nepal. Entering the street is a dangerous path. And I will not, and we shall not enter the street. We should find the solution from here. We have to continue to place trust in the institution, and we have to plead, we have to come again and again and again and again. And I tell the judges, even if you dismiss the pleas of the MSMEs 1,000 times, I am there with the 1,001 case, because what we ask for is not charity, but what we ask is for justice. Justice is our right, our constitutional right, and as a lawyer I am duty bound to fight for the rights of my litigants. Every lawyer is duty bound. Come what may, come whatever may be the personal difficulties, harm is caused to me, that will not deter to me. I will continue to fight with all humility and placing the trust in the institution and standing in front of the Supreme Court of India. It's a great institution. Individual judges may have made mistakes, but the institution is great. Thank you.